clearly had a great start, thanks to Martin. Dmitry Sugorevsky is going to take us on further. Some of the presentations are being recorded. I meant to ask Martin to talk about it. But just to say, Dmitry is going to record Amy also, but we're going to edit out the discussion, so don't worry, we won't be on this. Just
Hello, everybody. It's a pleasure to join the European Group on Sentencing, and we finished with the discussion of how judges and prosecutors might share a lunch or a bottle of wine or whatever. And this paper, paper project, tries to quantify exactly that fact. But before I start, let me introduce my institution, my affiliation. We are a small policy-related and academic institution within a university. Our mission is to promote the rule of law in Russia through research, and we combine academic research with policy, with informing policy, writing opinion editorials in Business Daily, and so on. My colleagues are mostly sociologists and a couple of lawyers. We do survey judges on the norms and behavior. We do try to model a trajectory of a criminal case, how it goes through the whole process. What I do, I analyze court statistics and court outcomes. We also have a ongoing project on the constitutional court and the issue of docket control. We have written a police reform which can be implemented in the fullness of time when the political environment is right. So a lot of stuff we are a team of 10. So for that, without further ado, I shall go to the paper itself. What we do in this paper is we build a population-based model of sentence length determination for 1.5 years in Russia. What I mean by saying a population length model is that we combine a unique data set on the universe of criminal sentences. We have 1.6 million criminal sentences, about 1.1 million sentences assigned a year. So what we do is we gather data of the complete picture of Russian judiciary. We apply and compare the existing parameterizations of those sentence length determination models that are in the literature, and with the unique richness of the data, we are able to extend it, go beyond the existing literature. But for this paper, we augment the models that we have developed in previous research with locational information on the discretionary actors, that is, investigators, prosecutors, judges, their courtrooms. So what we find, in a nutshell, that proximity matters. So, however, those findings are not very robust in statistical sense, but we find a strong effect for the prosecutor's office sharing the same building or being on the same street with the courtroom. With the police, it's still a bit ambiguous, sometimes significant economically, criminologically, and statistically, sometimes not. But for prosecution, we do see. Motivation. Empirical literature on criminal sentencing is quite vast, but it focuses on either biases, racial, gender, or status biases, or it addresses specific points, specific legal points, that is, plea bargaining or defense counsel and so on. And the research is US-centric, so there is a handful of papers outside the US. And so what we seek to contribute to both of those points, first we go beyond US, and second we go beyond those two foci of the research. So the structure of my talk, first I will introduce you into the data, and I will have to talk about Russian criminal justice at a glance. I'll stay with 2 slides, I promise. Then the data, then I'll try to build a sentencing model. Depending on your interest, I can show you the full model, and then go with the augmented one with the prosecution, with the proximity data. So the results are in the last section, and for the discussion, I will ask for your help, because this is a project, not a paper yet, so I would love to link theory to what I find. So let's start. Russia criminal justice is a civil law system with new inquisitorial procedure. In 2003, they tried to add a touch of adversarialism to this procedure, but not very successfully. So it's quite inquisitorial. There is a strong continuity with Soviet justice. In interviews with judges, you actually see how they share experience among generations and how they adopt best practices that were available in Soviet times. So, in terms of procedure, there is a very peculiar characteristic, a duplication of investigation efforts. So, there is a formalized pretrial investigation. Next slide will build on that. So, it forms a case file, and based on this case file, all the facts that are found by the investigation, before that by the police, go to the prosecutor's office. Then the prosecutor approves this case file, it goes to court, then the judge faces the same case file that the police opened. So, and then he decides on the basis of this case file. What's the role of the defense in this procedure? The defense judge is bound to consider only the facts that are in this case file, which can be that thick or that thin for a petty theft. So, evidence of the defense is presented at the same time at the trial, and the defense can make motion to exclude some of the pages, that is facts, from the case file. So that's how it's done. You can see that it is flawed, but alas, that's the world's second largest judiciary, and the criminal procedure is a bit strange. Numerical facts, jury is practically non-existent, less than 0.1% of cases. Plea is about 50%. That's again a very special type of plea. I won't dive into that now. If you want to have summary statistics to show you, just ask. So, what are the discretionary actors? Think of it in terms of filtering rules. First, first there is a crime. The police investigates. Or even before that, it has to register crime. So there is a reason not to register crime at some point. Then this this registered crime goes to the investigation. It can be either within the police or in a separate committee, investigating committee, and then investigator can dismiss this registration case, and then suspect appears. Then it goes to prosecution, so deal of indictment, and there is a separate filter there when the prosecution does not want to prosecute this person. Then there is a court dismissal, and then there is appeal. So it is quite convenient to think of how discretionary actors are located in the procedure in this diagram. So let's talk about data now. There is a three-tier system of courts of first instance. First, there are courts of peace, about 5,000. Let me double check. About 6,000 judges. So judges of peace that deal with, think of it very informally, with misdemeanors, like legal cases and so on. There are district courts which deal with non-aggravated homicides and so on, and there are territory courts which deal with cases of terrorism and so on, one per region. There are 83 or now 85 regions. So those courts have to register every single court record in a computerized system. And those court records go to the judicial departments of the Supreme Court, and then they go to the Supreme Court. So we gained access to this microdata on every single accused person by those three types of courts, except military courts, they are not there. So we also extended those records. So what we know, we actually know a lot about the the sentenced and people tried. So we know the gender, age, occupation, whether they have dependents, what were the prior crimes that they committed, what was the current charge, how many charges, when was the crime was committed, whether it was a plea or not, so whether it was a crime committed in a group. We also know a lot about the sentence type, when the sentence was assigned, and we also have upper and lower bounds of sentence from the criminal code. So we also have some extensive external data on judges, like the sex. Russian names carry grammatic gender, so we can extract the gender from the surnames. The geographic location of every court, the tenure, and so on. So what we did, we located every single court in the country, a district court. We don't have locational information on courts of peace, but they are not very interesting to this analysis now. And we actually have a website. If you are interested, we have all this data published in an interactive fashion. If you're interested, feel free to explore it or ask around. So for this research, for this paper, I focused on adults sentenced to real incarceration. First, let me introduce a sentencing model, and before that, let me ask you, are you familiar with regression analysis in any way? So, okay, I can proceed. So,
I think maybe some are, some aren't, but just looking for
I'll just,
some people.
yeah. Reasons. Yeah, I see the people who are nodding. Basically, we parameterize sentence length for any particular individual sentenced by Judge J at Court C as a combination of some legal factors, that is whether he is a repeated offender, what was his charge, and so on. Some extra legal factors, his age, gender, and so on. Judge level variables and courtroom variables. And for this paper, what we focused on are the courtroom variables. And the proximity information, proximity with prosecutor will fill in through those controls. We tried a lot, experimented a lot with those parameterizations, what controls to include, whether to include, say, number of dependents that convict has. So there is, again, a separate paper on that. And notice that this model has all the charges in it. And you can expect that there are inherent differences in sentences for murder. That's length of sentence, that's its distribution. So the blue line is murder, right? Murder, typical sentence for murder is 8 years. And there is another extreme in petty theft, or was it theft? Yes, green line of theft. So for those guys, typical sentences less than 1 year. So in this model, we use some econometric techniques to pool all those charges together. But let me skip that. Now, I've already started talking about how to augment the model. And if you want, I can show you the basic. I have 10 more minutes, so if you want, I can show you the basic results from this model, or I can jump to the augmented section. So, okay, thank you. So, a note on the presenting the results, just for presentation, for the convenience of presentation, I present them from focal concerns perspective. That is the perspective in sociological literature and in sentencing research that postulates that the attention of judges is guided by three basic focal concerns. That is blameworthiness of the offender, protection of the community concern in assigning the sentence, and practical constraints and consequences of sentencing. We augment this three-tiered system with two additional concerns that are particularly interesting in our context, in Russian context: rehabilitation and family factors, and protection of the community extra-legal concern. So, okay, these are basically the results. If you look at this, last column, because it has all 5 important concerns we have included in the model. This is the dependent variable here, length of real incarceration. Those are basically the percentage points of the effect of one additional charge that person has. So if a person, ceteris paribus, has one additional charge, the sentence length is increased by 9%. So those are the crime progress. So if the crime was in preparation, BAM minus 26%. So there is not that. Everything is as it is expected. So the benefit is that we can calibrate it now, know the precise figures. However, when we go to the protection of the community concerns, legal factors that matter for the judge, we detect a very interesting puzzle. Criminals can have records priors, and some of those priors can be expired. That is, he might have done his time, then he might have rehabilitated, and so his criminal record is expired. And by law, this expired record should not influence sentencing. But we actually do see that it not increases, but decreases. So that's a puzzle we observe. An interesting story. I have 7 more minutes, so I guess I'll have to skip that. Another interesting story in the full model is that rehabilitation and family factors do not work. That's a big puzzle for us. So whether the person is married, no relation whatsoever on the sentencing bank, and whether he has dependents. Again, we have some explanations for that, but for the sake of brevity, let me move it to the discussion section. And there come the organizational factors, whether it pleaded guilty and the case went in fast-track mode, so it decreases the sentence length, but not that much, 10%. So, yeah, that's the question of how much you give up and how much you gain. So, rational choice. Male judges do not really here. Yeah, this fact is not robust actually. So male judges are not very. We cannot really say that they sentence more harsher than female judges for, say, rape cases. But why did I stop on this slide? Because this is where we will have proximity story coming from. Actually, let me augment the model. For now, we found it increasingly difficult to find the locations of the prosecutor's office, investigator's office, and so on. So we built a random sample of 100 districts, again, random across cities and rural districts, rural areas, were manually coded whether the discretionary access, court, police investigation, and prosecution are either in the same building, or in neighboring buildings, or on the same street, or located further away. So actually we have 78 districts and 22 cities, again random sample. With enough budget of time and resources, we will extend it to 2,000. But for now, thank you. So that's the summary statistics. The distribution actually for the whole actors, say prosecution and courts, they share same building in 13% of cases, right? And the most puzzling thing to notice is that sometimes court and police do share the court. And Russia is vast, so in some regions, in some disadvantaged regions, that's normality rather than an exclusion. That's the summary statistics for for districts, rural regions, for cities, but I'll skip that. And here are basically the main results for this paper. We contrast the sentencing behavior of the judges. We have around 8,000 sentences to real incarceration assigned in those in those 100 regions. So apart from the 5 focal concerns we have in the model, we augmented with those with this information of whether the court and prosecutor's office are in the same building, in neighboring buildings on the same street, whether the court and investigator's office, and so on. And we get some, again, the slide is cut, so we get some interesting results in some parameterizations. The main takeaway from this is as follows, that investigation is surprisingly, let me go to the next slide, I guess, give it more better interpretation. For investigation, what we see is that the collaboration works for minor offenses. Yeah, again, I do it in very informal fashion, stating those results, but it doesn't work in more grave offenses, that is, the sentence length assigned. For prosecution, interestingly, there is a very strange variation which is not robust across how we define proximity, whether they are on the same street and maybe buildings or in the same building. So, and with the police station, again, with increasing sentence severity, what we see is here for grave, for misdemeanors, same street somehow works. Again, I will keep those slides for you for the interpretation, but it does not work further on. Again, I have a separate slide for qualitative takeaways. Proximity seems to matter most for prosecution-court relationship, and that brings us to the picture I showed you before, the filter, where prosecution and court are the actors sharing one filter, the closer to one another in the procedure. And there is also qualitative evidence for that. Public prosecutors who actually take the case to court, they have chambers in courtrooms. So not only do we capture the proximity through the office locations, but also the effect of the chambers in courts. So this might be actually a very interesting policy question. I think one more minute. Whether we should have those chambers or not. But again, we have interesting nonlinearities in terms of sentence length, harshness. Does this proximity work at for the harsher sentences or for more lenient sentences? Again, we see that for different actors it's different. But I think the most interesting legal terminological question is that whether there is this mapping from filtering rules to geographic proximity, the influence of geographic proximity that we detect. Why is prosecution the strongest proximity factor? Is it because it is located closer or not? So, yes, I'm out of time. Yeah. Thank you for your attention, actually. And I will ask your input on that.